Good afternoon and hello everyone. Welcome to today's event, the FTCA Office Hour for Clinical Leaders, Session 1, sponsored by the National Association of Community Health Centers. My name is Elizabeth Breidenbach. I'm a meeting and event specialist based in the Clinical Affairs Division here at NAC, and I'm pleased to bring in this event along with my division colleagues. Before we get started, I would like to review a few housekeeping announcements. You have joined this online event by either physically calling in or using computer audio. All attendee lines have been muted and will be muted for the duration of this event. The duration of this live event is approximately 60 minutes, including introductions, presentations, and Q&A. Again, the duration of this event is approximately 60 minutes, including introductions, presentations, and Q&A. I would like to thank everybody who did, and no problem if you did not. If you submitted those questions in advance, thank you so much. Our lovely panelists do have all of your questions, and they're very excited to answer them. If you do have a question in today's session, as it brews up in your mind, please use the chat box. It's located in the lower right-hand side of your computer screen. Simply open that chat box, type your question, and make sure you either submit to all attendees or to everyone. All of the panelists will receive your questions, and we'll try to answer your questions in the time allotted. If for some odd reason we cannot answer your question in the time allotted, or we do need additional resources, we'll make an attempt to reach out to you after the webinar is completed. Friendly reminders that today's event is being recorded. All attendee lines have been muted and will be muted for the duration of this event. Please place your comments, questions, or concerns into the chat box located at the lower right-hand side of your computer screen. If for some odd reason we can't answer your question in the time allotted, we will make an attempt after the event is completed. And last but not least, when you exit out of WebEx today, you'll be presented with a brief survey. This survey lets us know how we did, how valuable this event was to you, and directly informs us of future training and technical assistance. We value your feedback and encourage you to complete this very brief survey. At this moment, I'm going to turn things over to Marty, who's going to be introducing our lovely faculty today and taking it from here. Marty, the floor is yours.
Thank you. I'm going to first allow Molly to introduce herself, and then Keith, and then I'll take turns, and then we'll dive right into the program.
Oh, great. Thanks, Marty. Good afternoon, everyone. My name is Molly Evans. I am a lawyer at Feldsman Tucker, Lifer Fidel here in Washington, D.C., along with Marty. And I work pretty much exclusively with health centers and PCAs on a number of matters, including compliance and risk management, and importantly for today's conversation, the FTCA.
Keith?
And I'm Keith Horwood. I'm a family doc at Community Health Centers in Salt Lake. I have been here long enough to remember the days when every dollar that we got from our federal grant took 30 or 35 cents out of it and mailed it off to a private malpractice carrier, which felt horrible, and have been so appreciative of the FTCA program over the years. As a clinical leader, I see it as one of my primary responsibilities is to pay attention as best I can to make sure that the terrific coverage that we have available, some of which are benefits that you can't get anywhere else, are protected and available to our providers. And so that's why I try and pay attention and learn as much as I can about this. And I'm happy to share what I've learned and to respond to the expert advice that we'll be getting from Molly and Marty today.
Thanks, Keith. I'm Marty Bree. I'm an attorney with Feldsman Tucker and Lifer Fidel, and I spend most of my time working on the FTCA program. Formerly I was a commissioned officer with the Public Health Service. I spent 28 years working in HRSA with health centers. That's essentially been most of my career, and I've enjoyed it every step of the way. So let's dive right into the program today. The idea here is for us to be able to provide answers to the questions that you all have around the FTCA program and the current issues facing it. Many of them derive from the pandemic that we've been facing for the last almost 2 years now. So we've already got a number of questions come in through the chat room. And what I think we'll do is we'll deal with those questions that have come in through the chat room. I have a couple of slides that are really designed to elicit questions from you all as well. So we can have that next slide. And well, there we are, our faculty member. We look pretty good in those pictures. Next slide. Okay, here we are. So these are some of the areas that over the last 12 to 18 months, we've been sort of inundated with in the area of questions and queries. So let's first start off with some of the chat questions, and then we'll go into these other areas. If you think you have a question in any of the areas, let's get it to us right away so we can answer it, okay? So the first question, what policies and procedures should be implemented in light of the pandemic, and what is appropriate review intervals for procedures during ever-changing pandemic environment? I think I'll start with Keith on that one. What have you all done in terms of newer policies and procedures that you've gotten, that you've written because of the pandemic? Keith, you're muted.
Oh, shame on me. Forgot to unmute. So I wish I could give you an answer to say how often, but part of the answer is implied in your question. Things keep changing. And so I think what we have to do is try and pay attention and change as often as the setting changes. So, you know, before we had a vaccine, we didn't have vaccine questions. Before we had monoclonal antibody, we didn't have those questions. And so our executive team, you know, meets every week, and every time we meet, we take a few minutes to say, has anything come up that will be changing our practice or our procedures? And if those things change, do they have any FTCA implications?
Keith, during the last 2 years, we've seen an increased use in telehealth as a way of delivering services. Has your organization created a new policy around telehealth or amended an existing policy? And can you tell us about that?
Yeah, we did very little telehealth before the pandemic, but we obviously were, you know, trying to restrict the amount of virus exchange happening at clinic by really ramping up telehealth. And there were a number of questions that came up for us. First of which was, in general, how did FTCA apply? And specifically, one of the questions that came up for us, although all of our clinics are located in Utah, we do have patients who come and see us from Nevada and from Wyoming and occasionally from Idaho at one of our clinics in the north. And one of the questions that came up for us was, if we're doing a telehealth visit, where is the care occurring? Is it occurring where the patient is, or is it occurring where the provider is, or is it occurring at the clinic, even though neither the provider nor the patient might actually be in the clinic on the day they had their telehealth visit?
Yeah, that's a great question. Molly, do you have any thoughts on that?
I think that generally what we would say is that, I mean, you have to look at there are a variety of rules to look at: licensure rules, billing rules, state law around the telehealth visits that determine the requirements that you might need to take into account. I think as a general rule, the location of the patient is the location of the visit for licensure purposes. So when you have a patient that is out of state, you want to make sure that you have either your providers are aware, either they, number one, have a license in the other jurisdiction, number two, you are aware of what those licensure requirements are. Number three, you're aware that if there were flexibilities during the pandemic that are expiring now around licensure reciprocity or flexibilities around providing telehealth from outside of the state. Those are all sorts of things that would be perfect policies and procedures, to Keith's point, that you want to reevaluate as time goes on. I think the interval piece will really also relate to when particular things like public health emergencies are expiring, like flexibilities that you might have in your own work environment around remote work are expiring. Those sorts of things would be the considerations. And we could probably come up with 200 new policies and procedures that should be implemented in light of the pandemic. But I think that the idea of meeting and sort of evaluating what sort of things you're doing that are new that you haven't done before as a health center is a good start for those policies and procedures. And then also the considerations around emergency management. If you are you're doing a risk assessment and you are evaluating those sorts of new risks that you have, and then developing policies and procedures in those instances. And then finally, I would say taking the lead from various requirements from various federal and state agencies. So, for example, the OSHA emergency temporary standard, those sorts of things are going to drive the kinds of policies and procedures that you need to have in place at the health center.
Thank you, Molly. We could talk for another 3 or 4 hours on telehealth.
Yes.
Yes. Let's get on to some of the other questions. And if we have time, again, at the end, we will go back because I have some more telehealth questions for you all. Another question we have are consideration. What are the considerations for FTCA coverage of monoclonal antibody treatments and or provision of monoclonal antibodies? And I think that getting at the question of if we do that through a infusion therapy, will there be FTCA coverage of that? Molly?
So I think that the question would be, what kind of service is this that the health center is providing? So in this case, it's an infusion service. And is that something that health center providers are doing within their normal scope of employment and their scope of project at the health center, that this is just another medication that they would be providing through an infusion? And that's what you want to think through. I think to the extent that your providers, your family medicine or internal medicine providers are providing this therapy, you would want to have a consideration and ensure that it's part of their delineation of privileges as the type of activity that they provide at the health center. But in general, I think I would like to hear Marty's perspective on this, but I think that we feel comfortable that FTCA coverage would not be an issue. Marty, is that your sense?
I tend to agree. When I think about it, it's really a pharmacy service, and we're providing a drug. We can do that either through prescribing oral medication or perhaps through an injection, which we wouldn't question. And now we're providing it through an infusion therapy. And so, my question would be, why is that different? So long as your staff are qualified to do that, it's not a specialty service per se. It depends on what's the underlying ailment that you're prescribing the monoclonal antibodies for. And treatment of COVID-19 is a general primary care function. That being said, there are some other protections you may have under the PrEP Act.
Mm-hmm.
That might cover, and I don't recall whether monoclonal antibodies have been declared to be a covered countermeasure yet. I would imagine they have been. We have to look that up. But anything that's been declared to be a covered countermeasure, for example, a vaccine or some other treatments, if you're administering them and you meet some other requirements, you have an immunity from lawsuits from the PrEP Act as well. So in this case, we may have layers of coverage.
Mm-hmm.
Okay. Keith, anything to add?
Yeah, we have not spent a lot of time on this because the way that the state has distributed the monoclonal antibody, it's easiest for us actually to just sign up patients with a large vertically integrated health system that we're part of to go to their sites, and patients, whether they're insured or not, are, if they qualify for have the appropriate conditions that qualify them for a monoclonal antibody treatment, they just go in and they get treatment, and we're made aware. But we're not actually doing much of that.
All right. Third question. Is there a final date that all health center employees need to have completed their COVID vaccine for the health center to be in compliance with the president's COVID-19 ruling? What is the date and what happens if they're not compliant? Molly, I'm going to thrust that one on you.
Okay. So the answer is no, there's not a final date yet. We are still waiting for the rules that are going to be promulgated based on the president's COVID-19 plan for under the CMS interim final rule and the OSHA emergency temporary standard. The OSHA emergency temporary standard will apply to employers with 100 or more employees, regardless of the industry. It's not specific to healthcare. The CMS rule applies to all certified Medicare and Medicaid facilities. It is likely, although we haven't seen the rule, it is likely that health centers will be part of that when that rule is published, and that will apply to healthcare workers. We'll wait to see what that definition is too, but we know that the OSHA ETS went to the president's, to the White House from OSHA last week. And so we're waiting to see what happens with that. And we know the CMS rule is coming out soon too. I think we expect both to be out by the end of the month, but we're waiting to see. So stay tuned for those. If you are a federal contractor, and that doesn't mean that you get a grant, a 330 grant, it means that you have a federal contract, or you're a downstream contractor from another organization that has a federal contract, then you also have a mandate to have vaccinations, and that actually is by December 8th. But that's a much smaller universe of health centers than most of you who will be under the OSHA rule and likely the CMS rule. Some of you if you have less than 100 employees, the OSHA ETS won't apply to you. But those are the ones that we would see, and we will have to wait to see what the runway is for those particular dates. And we're staying tuned, and NAC is very much staying on top of that, and will be in touch as well when these are published, so that we know what happens. What will happen if you're not compliant? Under the OSHA rule, there could be fines associated with not being in compliance and not having a safe work environment. Under the CMS rule, I think eventually Medicare or Medicaid payments could potentially be withheld, but we have to see, and we don't imagine that that's going to happen, the day after the rule is published. There'll be time to come into compliance from what we've seen, and we'll just continue to stay on top of that.
Molly, would you anticipate that once these rules become final, that FTLF will have a webinar on that topic?
Yes, absolutely. We will have many, I'm imagining. The other thing I should mention is that there's a lot of litigation that is likely going to come up in the meantime across the country, not necessarily from health centers or not from health centers, but for example, the last time I checked, more than half of the attorneys generals of this 50 states, so at least 25 attorneys general, were planning to sue the federal government on the OSHA rule. So, there's a lot that will happen before we have a clear guidance about when these mandates have to come into effect. I think one of the things that has been confusing is that when Biden released this plan, the idea or the impression was that these things were in place now, and the reality was, with the exception of the federal contractor piece, on the OSHA rule and on the CMS rule, he basically instructed these agencies to have rules promulgated. It didn't set in motion the mandate themselves.
All right, let's move on to the another question, and this one's regarding deeming applications. Requirements for initial deeming applications include posting language throughout the facility on the website that will maintain FTCA coverage. Is this required to implement prior to submitting initial deeming application, and should we expect a site visit? That's a good question. I'll answer the first part, and then Molly, you can grab the second part.
Okay.
If truth be told, there is no requirement to have a notification of your limitation of liability or your FTCA coverage unless you're in the volunteers program. But for the health center program, there really is no requirement. But HRSA expects that you have a notice on your the homepage of your website. And even though it's not a requirement, it's a good thing to do. Even if HRSA didn't have that expectation, we would probably recommend it because it can help to eliminate unnecessary state lawsuits. And it helps to guide the patient to the right venue. Should you have these in place before you submit your deeming application? I would say have it ready to go once you get your notice of deeming action. And the day you get that, then you get that posted on your website. Molly, what about site visits? Should you expect a site visit?
I think, yes, I think the language that that the FTCA division has published is that you can expect a site visit when you are submitting an initial deeming application. I don't know if it bears out that every single health center that submits an initial deeming application has a site visit, but it's certainly in the guidance about one of the expectations that you would have is a site visit. And there is a site visit protocol that you can use to prepare for that. And the other thing, Marty, is I think you may have to submit the link to your website
Yes.
in the deeming application itself. So presumably you would have that done when you are submitting the deeming application, because I think that's part of the uploads. If I recall correctly, that may have changed, but I think that's.
Yeah, there's a way around. Yeah, you can just, your note could say effective such and such, effective on whatever. It's not a big issue, but yeah, you're right. They do ask to see the screenshot of that notice. Okay.
And are those site visits currently live or virtual?
They're virtual. And we haven't heard when they will go back to being in person. I would say not before the end of the year, but
Right.
I think we're waiting to hear on that.
I would expect you'll get a significant amount of notice.
Yeah.
On that. Okay. Next question we have are, will dentists be allowed to administer other vaccines to bridge gaps in cares? For example, flu or HPV. They have been granted exceptions to administer COVID vaccine, but what about these other vaccines? Is there federal law that trumps state law? Who wants to jump in here about, how about in your state, Keith, and dentists administering vaccines?
Yeah, I don't know specifically for dentists, although we have been allowed to have our dentists, particularly when they were idled, because the procedures they do are much more likely, virtually all of them cause aerosolization. So it was harder for them to remain open when we didn't have rapid testing in order to improve safety. But we were free to mobilize them to vaccinate. I mean, these are folks who can hit the maxillofacial nerve on the left side, with a tiny needle. They can certainly manage to, hit your muscle in your arm. And so we were free to do that. I know that's not the same everywhere. And there were some states whose legislatures even specifically said, you're not allowed to let dentists do this, which didn't make any sense to me, but I perhaps expecting for all of our governmental organizations to make sense is not a rational thing for me to do. But that's going to be a state by state sort of answer.
Yeah, I think you're correct. It depends on what your state allows the individual provider to do. And you're also right that states have varied on this question about what dentists can and cannot do. Is there a federal law that trumps the state law on this? I don't believe there is.
No, I don't think so either.
All right, let's go on.
Honestly, the only thing that we have found troubling about that is that as those expand elsewhere, we have some patients who feel like their well child visits during the first year of life. Well, if they got their shots, that's all they need. And so they might go to the health department and just get shots, but not any screening for developmental issues, not any screening for growth. And those services are different in different places as well. But our only real pushback has been to say, how do we make sure to encourage our patients who may not have the sophistication to know what the critical part of that 4-month well child check is, to think that they're done after they've had a couple of vaccinations.
That's a really good point.
Yeah.
In terms of why you might not want other members of the staff to do it for that purpose.
Okay, another question. This is a good question because we get it a lot. Please review exactly which staff are required to be current with basic life support when completing the FTCA deeming application. For example, do behavioral health licensed therapists need to be BLS certified? And that's a good question. And if you read all of the writings that HRSA has put out regarding basic life support, one can get confused as to whether everybody or only one person per site or only your clinical staff need to have BLS training. Molly?
So the answer is, so I'll review all staff and then I'll answer the example. So, and it's, by the way, not just the deeming application, but it's also Chapter 5 of the Compliance Manual for Section 330, which says that for credentialing and privileging, that the health center has to have operating procedures for credentialing of licensed independent practitioners, other licensed and certified practitioners, and other clinical staff. So licensed independent practitioners, that's all of your providers that can provide services independently. Other licensed and certified practitioners, those are members of the clinical staff that have a license or a certification but don't work independently. People like RNs, LPNs, some social workers, depending on what state you're in. And then other clinical staff, these are people who work in the clinical staff who participate in patient care but do not have licenses or certifications. Those, all three classes need to have credentialing and privileging for both Chapter 5 of the Compliance Manual and for deeming. So, and credentialing includes basic life support, evidence of basic life support training. So all three classes, including those other clinical staff, and that means people like medical assistants in states where medical assistants aren't required by state law to be certified or licensed, or community health workers, other sorts of case management that don't require a license or certification, all need to have BLS training in order to be compliant with Chapter 5 of the Compliance Manual and as part of FTCA deeming. So the example here, do behavioral health licensed therapists need to be BLS certified? The answer is yes, they do. There's some confusion because the Compliance Manual also in the after hours emergency chapter says that only that one person per site needs to have BLS training. And that's also accurate, but from this perspective, for credentialing and privileging, basic life support training is part of the requirements for credentialing for all three of those categories of staff members. So I hope that is a review that answers the question, but it's very broad, and it's not. And the behavioral health licensed therapist is a question we get a lot because sometimes health centers are surprised to find out that their behavioral health staff also have to have BLS training, but they do.
Thanks, Molly. The next question we have gets back to the vaccine issue, but it's got another little twist here. Wants to make certain that pharmacists who do community vaccines are covered. So in my mind, that's really two parts to that question. Can pharmacists give vaccines? The answer to that one would be the same as for the dentists. It's up to what your state permits the pharmacist to do, and then what you've privileged your pharmacist to do. I think we've all seen pharmacists giving vaccines, so I would suspect most states permit that, but you need to check your state. But the second part of that question is the question around providing vaccines out in the community. Okay, let's say part of an effort to provide COVID vaccines under various settings within the community. Molly, you want to talk about that and the FTCA coverage and perhaps other protection?
Sure. So the FTCA regulations have a list of exceptions where the health center can provide services to non-health center patients and still have an expectation of FTCA coverage for the providers. And one of those exceptions is something called immunization campaigns, which means that the health center can be out in the community and provide immunizations to the public and still have an expectation of FTCA coverage. So in this question, to the extent that the pharmacists are permitted to provide vaccines in the community under state law, there should be no issue with that from the FTCA perspective around even though the people are not necessarily going to be health center patients because of this exception in 42 CFR 6.6. What I would say that is important, and Marty and I have been beating this drum since the beginning of the pandemic, is making sure that you have immunization campaigns as a category in your Form 5C to acknowledge that you are out in the community providing these immunizations. That is a belt and suspenders approach, but it's important to capture that in your Form 5C to acknowledge that you're doing that. You certainly don't have to list every immunization campaign every time you are out in the community providing vaccine, but you want to acknowledge that you're doing that by adding it to Form 5C.
Well, that's good. Thank you. The only follow-up I would have to that is the regulation doesn't address it, but how far afield can you go from the health center itself in the provision of an immunization campaign? Just in your service area? Can I go into the next county? How far can I engage in this kind of an activity?
I think that so there are a couple of different philosophies that HRSA has had on this. I think you're obviously safest in your service area. You're safe in neighboring and adjacent communities. If you're going across the state as part of a vaccination campaign, and that in your service area does not encompass the whole state, that's when we get a little more nervous. Even in the general determination, the McRae generalized particularized determination, there's language about how the federal government would like you to stay within your communities generally. If you're opening temporary sites, that's another consideration, and you can review those requests for opening temporary sites in an emergency and how far afield you can go from your service area. But staying closer to home is going to be safer. And I think if you are outside of the neighboring or adjacent communities or counties, then you want to make sure that you are clear around your coverage.
All right, thank you.
I'm not sure if this is really on point, but we had a question come up when we were doing a campaign where when vaccine was very first available, we had a clinic there where there was like a 1.5 mile line of cars coming into the clinic to get vaccinations. And the question we had was, sort of what about general liability if someone was in a car accident or, traffic was snarled or whatever. And someone, it's obviously not medical malpractice, but perhaps general liability that might be able to cover that or might not.
Yeah, actually, I think that's a great point, Keith, in terms of talking to your broker, particularly if you you haven't reviewed your general liability policy with your broker in terms of how your operations have changed. So, for example, I know that a lot of health centers at the beginning of the pandemic were going in for testing, but maybe now, frankly, are going in for vaccination to industrial parks, meat packing plants, etc. So I think that's a great question to talk through with your insurance broker. What does our general liability insurance cover, and those sorts of things are the kinds of questions that you want to make sure that the insurance carriers are aware of your program in general, and particularly if it's changed dramatically because of COVID.
Thank
It
you.
goes back to the first question about what policies and procedures should we be reviewing. The insurance policies are definitely something to review during COVID in terms of how things have changed. Same thing for remote work.
All right. Another question we have. Telehealth service has to be included in Form 5A to assure coverage by the FTCA ? And that's an easy question, and I take easy questions, not hard ones. So I'll do this one. Okay, I leave all the hard ones to you guys. No, you do not have to list telehealth on Form 5A. HRSA's been clear that telehealth is not a service. It's a mechanism to provide a service. So it does not have to appear on Form 5A. Molly, have you any thoughts about whether you want to put it on 5C?
No, I don't think it belongs on 5C either. It's a modality of a way you provide services. And I think there's been, HRSA has been clear about that. So I don't think you need to put it on 5C either.
All righty, I agree. Next
Marty,
question.
there was a question that was, I think, up in the chat that that got maybe lost in the shuffle, which was for peer review, is there a HRSA expectation physician residents or mid-level residents need to be included in peer review assignments?
Well, that's a hard question. You don't have to answer it, guys. Keith, what do you think about that?
Yeah.
Well, the first thing I would say is if they're residents, I'm not sure they're peers yet. They're in a training program, and so they're getting supervised and feedback and all sorts of things are happening, and they're not quite yet a peer who would qualify for even having the ability to do peer review. So that would be my first response. And my second would be, what I've already implied is that they're in a training program. They're getting lots of regular feedback. Someone's signing all of their charts. So I don't think it would be a very tough standard to meet to say, are they having their care reviewed? Yeah, all of it. Hopefully every visit is being supervised by someone.
I totally agree with that. That's my instinct as well, that it's not part of the general traditional peer review of the health center, but that's because it's part of their training program.
Okay. Next question we received. During an FTCA specific audit, we were told that the health center determines in its policy which staff have to have BLS training, and those staff will be reviewed to see if they have BLS certification in the file. So this is one I'm going to throw back at you, Molly. It gets to who was correct in their answer, you or the reviewer. And the other point is reviewers are not omniscient.
Yeah, I think, and it looks like there was a clarification too. We were not told all staff, only those identified in the health center's policies and procedures. So yes, there is within the Chapter 5 of the compliance manual, related considerations, it says that the health center determines who is in that category of other clinical staff. And I think that's my sense of what these reviewers told this health center, that the health center gets to say the following staff members are part of our other clinical staff: medical assistants, care managers, navigators, whatever the health center defines in that other clinical staff are the people that have to have credentialing and privileging, including basic life support training. And that's not going to mean that the CEO is in the other clinical staff or the patient revenue department, the CFO, the finance people. Those people are not going to be in the other clinical staff. The health center would define that. It does have to pass what we like to call the straight face test. You're not going to be able to say that medical assistants are not part of the other clinical staff, even though in the related considerations, it says the health center has discretion to determine that. But I think that's what, that is how that sort of relates to what I had said previously, that you're going to define the universe of this other clinical staff. But you want to do it so it passes that straight face test.
All right, that's, I believe, all of the questions that we received. So let's go on, and I can pose some other questions based upon some of these topics that are on this particular slide. And there are additional slides that you'll have available to you that list some of the issues around each of these areas. And so let's go with telehealth. First thing I wanted to point out that is that HRSA has published a program assistance letter 2020-01 on telehealth and scope of project. And that PAL, you can use that to help you in the way you report services provided by telehealth on Form 5A. And so that's mainly what that PAL is getting useful for. Keith, a question around telehealth visits. When you're conducting a telehealth visit or in your protocol for conducting a telehealth visit, do you address the issue of consent of the patient to have a visit using that methodology?
We have not directly addressed it. We are in the process of revising our general consent for treatment, and thinking about should we include that just as a sort of a safety measure to make sure that we're saying that. But I think in the same way that coming to a visit implies consent for seeing the provider, calling and saying, and we at the start of the visit are saying, there's a disclaimer that gets given to every patient that says this is not the same as an in-person visit. It provides services but cannot provide the same standard of care, and that you're agreeing to have this visit means that we will do our best, and we will also say we don't think this visit is appropriate to complete by telehealth. We think you're going to need to come to clinic for us to do right by you. So we're not specifically forcing a consent for this to be telehealth, but we are saying that because you're doing this by telehealth, you're recognizing that we have some benefits, convenience, and not having to be in a waiting room with someone who might sneeze. But it also doesn't allow us to look at you and touch you and do as complete an exam as we might.
All right, thanks. Immunizations. We talked about locations of physicians and patients.
I just had one comment on immunizations regarding the question about when will this be required. Our experience has been that most of the humans who work for us have carrying somewhere deep in them a 2 or 3 year old who is inclined to say, "You're not the boss of me," when you give them a mandate. And so we have had much more success in saying to our employees, because we care about your health and your ability to continue to work here, we're going to say in certain situations, we need you to protect yourself. And so for our employees who have for years had to have a hepatitis B vaccine, if they were going to be doing procedures that might result in blood exposure, we say in the same way, if you're patient facing, we're going to require you to have a COVID vaccine because we don't want you to put yourself or your mom who's living in your home and is on chemotherapy and can't really get an effective COVID vaccine, or your children who are not yet old enough, although that number just moved down quite a bit. We don't think it's ethical for us to allow you to face patients. And so If you have an exception to vaccine that is acceptable for religious or other reasons, we will do our best to find you work that allows you to not have to be patient facing, but we can't guarantee you work if you're not willing to protect yourselves and our patients. And so, we have our own reasons for asking people to either get vaccination or change their work or look for other work that I think has been more positively received than saying, well, because President Biden says so.
Thanks, Keith. And that leads me to another question. Maybe Molly can give us a little insight on this. Regardless of a CMS rule or an OSHA rule, what should health centers be aware of if they want to institute some sort of requirement for COVID-19 vaccines?
I think Keith mentioned this, but you want to make sure that you are evaluating appropriately any exemption requests by staff members in terms of whether or not they have a medical or a religious exemption from being vaccinated. So you certainly that has to be part of the calculus in terms of what the health center is going to evaluate. I will say also, and I think Jackie mentioned this on a NAC Found My Tea session yesterday, or maybe it was Monday, I'm losing track, but that you want to make sure that it's worthwhile to have your board approve a vaccine mandate policy so that your health center, because of the potential litigation that may come from staff members or staffing shortages, if you lose staff because of a vaccine mandate, et cetera, you want to make sure that your board is aware and blessing a decision to have a vaccine mandate, particularly if you're doing that ahead of a requirement from the federal government or otherwise, or a state or a local jurisdiction. I think that Keith's comments are very well taken in terms of having the ability to encourage staff members towards vaccination rather than moving towards the because Joe Biden said I had to do it approach.
Another thing that we have found helpful is we have specifically acknowledged that if we're requiring you to do this for your work and if you have a bad reaction, then it should be covered under, if it's part of workman's compensation, and we would support your assertion that that's the case. Yes, we told you that you needed to do this vaccine, and if you had a reaction that made you miss work for a couple of days or whatever the deal is, that we're not going to argue about that. We're going to say, sure, we told you to do that, and now we need to step into, supporting whatever consequences stream from that.
Thank you. Let's talk a little bit about testing and other off-site services. FTCA coverage for an event that you're participating in to provide, let's say, monoclonal antibody infusions, and yet say you're doing this in concert with the health department, where the health department has a site, they're managing it, operating it, but they're asking you to participate in it, and you send some of your staff to participate in it. And it's in your service area, make it even easier there. Molly, where are we on FTCA coverage of that?
So we're still under the generalized, particularized determination, I would say, where you are permitted to provide services related to COVID to non-health center patients outside of the health center. now, I guess the question will be, and we haven't heard, one of the questions that we had since the publication of that document was what is the lifespan of it and when will it expire? And we haven't heard that yet. So we'll have to continue to stay tuned to see if you are providing these services offsite, the availability of FTCA coverage for them. We, in a lot of conversations with the FTCA division, we had the impression that it was very important to them that when your providers are providing these services and when you're providing these services, it is on behalf of the health center, that you're just not leasing out providers to do work for another organization. So if there's an affiliation between the health center and the health department in your example, that's likely going to be better than the impression that the health center providers are basically warm bodies working for the health department, because the health department asked the health center to send them over. So those are my initial thoughts. Marty, do you have?
The only additional thought I would add is you're probably going to have to show that this activity was part of the scope of employment of the individuals involved. So you're going to have some documentation that they were sent to this activity on behalf of the health center, that you directed them to do this as part of their job. And that could be, if you have some general language in an employment agreement, or if you have some additional policy language or email documentation that you directed the individual to do this. So we need that. Always have to worry and be sure we can document the scope of employment question. Okay.
As opposed to them just volunteering at the high school for a drive,
Yes.
Which then wouldn't be.
Exactly.
Yes.
It doesn't follow them around, much to some providers' chagrin.
Yeah, exactly. Volunteers. Volunteers aren't covered by the health center's FTCA program, but Molly, what else do we have in our hopper for them?
So absolutely right that volunteers are not covered by the health center FTCA program, but there is the availability of getting coverage for them by applying for them as a sponsoring health center through and getting them individually deemed to work at the health center and have FTCA coverage. There's also availability under the PrEP Act, as Marty alluded to earlier, in other other federal legislation that allows Volunteer Protection Act, PrEP Act, et cetera, that may have some coverage availabilities. I think when we've worked with health centers and using volunteers, one of the concerns I've had is that the health center is giving the volunteer the appropriate impression of the volunteer's own malpractice coverage for the activity, and making sure that the volunteer is not misinformed about their requirement to provide their own malpractice coverage, particularly if the health center is not going to be applying for deeming. These availability of coverage under things like the PrEP Act, et cetera, would be the responsibility of the volunteer to pursue if there was a bad outcome or a lawsuit, not the health center. So I think having caution around how you're describing the availability of working at your health center as a volunteer, to not make any promises that the health center is somehow going to be responsible for the malpractice coverage, I think is important.
All right. Let's go down. We still have a few minutes left. Let's talk a little bit about credentialing and privileging. And the question often comes up in these situations. We have volunteers, regardless of the FTCA coverage or not. Do we have to credential and privilege the volunteers who are helping us out during this period of time?
Yes.
Very simple answer.
Were you about to say something?
Keith?
No, I was going to say yes, but.
Okay. Yeah, it's a very simple answer to that question. Yes, they have to be credentialed and privileged. But in an emergency situation. That can take a lot of time, right, Molly?
Yes, and there is some availability for temporary privileging that can allow you to move more quickly when you have in an emergency with credentialing and privileging volunteers or frankly anyone. Just to keep in mind that there is no such thing as temporary credentialing, even though that term is used. You either have the credentials or you don't, but you can have temporary privileges, and there is availability of those for in an emergency that you can ensure that you have in place.
Great. Yeah, just for your information, that is a streamlined process you can find in Program Assistance Letter 2017-07, Temporary Privileging of Clinical Providers by FTCA Deemed Health Centers in response to certain declared emergency situations. Which leads to the next question I have is that the only time you can use temporary privileges? Are they prohibited by the compliance manual except in this circumstance? That may be a trick question.
That's why I'd like you to answer that.
It's another one I don't answer.
So it shouldn't be. It shouldn't be prohibited, but we have seen reviewers take the position that because the concept of temporary privileges was removed from PIN 2002-22 and you can't find it in the compliance manual, that it's somehow not available now. We disagree with that. We've gone back and forth on that. But that's something to be aware of, I guess I should say. I don't think we've had any resolution.
No, if you're having a site visit, if you have a provision for temporary privileges, similar to what's in 2002-22, you should be ready for a reviewer to perhaps tell you that you can't have that temporary privilege process. Again, we don't think that's correct, but just be alert to that. There are
a couple of new questions in the chat box.
Okay.
One about establishing as a health center patient via telehealth, so never having been physically present. And I've been told by some folks who say, yeah, until you actually come to the clinic, you're not our patient, even though we went and saw you at the nursing home or in the hospital.
Well, HRSA in their FAQs has clearly implied that you can become a health center patient via a telehealth visit. Unfortunately, that's just an FAQ. It's not they didn't put that out in the policy information notice. They haven't revised the FTCA manual to address that. But it is a question. It's going to be an ongoing question that we would expect HRSA is going to address. Okay. In credentialing and privilege, can a provider request reasonable ADA accommodation by law, even though physically or mentally an underlying medical condition is affecting its fitness for work ability or mental ability? Is it covered by the FTCA? I guess the question really is, what's the relationship for fitness for duty determinations and your ADA requirements?
You want to really work with an employment lawyer on that. That is a sticky wicket, particularly if it is a mental ability. I'm not sure what the FTCA question is on that. But there may not be, if the mental ability of the medical condition is affecting the provider's ability to be fit for duty, then it sounds like, and it cannot be accommodated through a reasonable accommodation. That sounds like a problem. So yeah, those are so fact specific that I wouldn't want to answer that on here, but I would say to work with your employment lawyer on that, or your employment practices liability insurance carrier can maybe help guide you, but definitely something to be very cautious around.
Thank you, Molly. I think we are just about finished. Liz, Katja?
Yeah, thank you guys so much. That was such a fantastic presentation. Really appreciate that. As you know, on the screen right now, we do have some additional resources for you, and we will be sending those out via email as well. We want to thank you so much for joining us. Our next FTCA session is going to be on December the 15th. And again, we'll see you again in February of next year. Weird to say that, but yeah, we have 2 more sessions signed up. When you originally got the link, you should have been able to register for the entire series. So you should have an Outlook invitation from WebEx for the next 2. If not, please revisit that email notification. Either you got it from the HRSA Digest or you might have gotten it from NAC. Feel free to register. Feel free to share this with a friend. We really appreciate that. Again, this has been recorded. It will be available for playback in the clearinghouse. Once we have the editing and everything put up for you, we'll send everybody a link. You should have received the PowerPoints as well, or a PDF of the PowerPoints as well today upon logging in. Thank you guys so much. We will see you in December for our next session. Have a great day. Thank you. Bye,
Thank you.
everyone.
Thanks.
So-
Thanks.